Welcome, everybody. Thank you for joining us today for this panel on the rights of nature. My name is Margil with the Center for Democratic and Environmental Rights, and I'm joined today by two distinguished panelists, Thomas Linzey, the co-founder of the Center for Democratic and Environmental Rights, and Guy Reiter with the Menominee tribe. We're going to be presenting a bit today on what's happening with the rights of nature developments over the past 15 years or so. So thank you again very much for joining us. We're going to talk today about the rights of nature developments in the United States within tribal legal frameworks as well as overseas outside of the United States. And I'm happy to introduce our panelists. As I mentioned, we have Thomas Linzey. He's senior legal counsel with the Center for Democratic and Environmental Rights. He worked on the very first rights of nature laws drafted and adopted anywhere in the world. And we're going to start with him today to talk to us about what the rights of nature is and how things have developed over the last decade or so. Thomas.
Great, thanks, Mari. I know we're all probably tired of staring at screens. I know I am. So we're going to try to make this as interesting as possible today, which luckily for the subject matter, that's not that hard to do. So what are we talking about today? So just to set the virtual stage kind of for this conversation, we're talking about recognizing human civil rights type protections for nature. So again, human civil rights type protections for nature. And that kind of bends our brains sometimes because we're used to talking about civil and political rights for people, for humans. So we're all familiar with First Amendment free speech rights and Fourth Amendment rights in the US Constitution against unreasonable search and seizure, basically talking about civil and political rights in a human context. What we're going to be talking about today is how to take environmental protection within the United States and elevate it to that level of rights. Because as a society, when it's understood that there are commonly held values, the way that we protect those commonly held values at the highest level is through recognition of rights. And so from an environmental protection standard, we're talking about heightening or strengthening those standards to a level of rights, similar to how we do it within human society, which is recognizing these commonly held values as rights. So I don't think any of us would be talking about this new system of environmental law that's rights-based if we had an existing system of environmental protection that was actually working, existing system of environmental protection that was actually functioning. And I don't think you need to be an environmental lawyer. You don't really even need to be an activist or an organizer to understand that things are kind of falling apart globally, whether it's climate change, whether it's acidification of the oceans, whether it's deforestation. We're in a bad place. And the statistics bear that out, in essence, that we're in the worst place now by almost every major environmental statistic than we were 40 years ago before the major environmental laws were passed. So what do I mean by that? Well, we release 4 billion pounds of toxic chemicals into the atmosphere annually, and that's just in the United States. So 4 billion pounds of toxic chemicals released. And I would also add that's legally under a permitting system, so allowed to emit 4 billion pounds of toxic chemicals. We have 80,000 industrial chemicals in use. If we tested human bodies of everybody that's in this room, you would find close to 700 now are found within every human body, so these industrial chemicals. Half of all plant and animal species have been driven to extinction. 90% of all original forests have been logged. 40% of all waterways still fail to meet minimum clean water standards in the United States. So basically, we're kind of screwed, just to put it in a very simple language, simple words. In terms of where we sit now under this current environmental law system. So it's not enough to recognize that the current system is broken somehow or isn't working for the values that we all share. It's the question of what does a new system look like? And I don't think anybody really grapples with what that new system looks like or comes to the conclusion that our existing environmental system is not working, except mostly for people that have worked in the field as environmental lawyers or as people who are activists, community leaders who have tried to make this system function. And I don't think my journey was any different as an environmental lawyer from a nonprofit law firm named CELDEF that I started 25 years ago and left about a year ago to form this new organization, the Center for Democratic and Environmental Rights. But for about 10 years, my job was to try to make those existing environmental laws work. So the Clean Water Act, the Clean Air Act, doing permit appeals, land use appeals, those types of things. And what we found overall was that in the end, we were trying to enforce regulations, environmental regulations that had been drafted by the very corporations that ostensibly were supposed to be regulated by those regulations. Kind of a hamster wheel kind of existence in which the job was to appeal environmental permits, but at the same time, you understand that you're appealing these environmental permits under laws that were created by the very entities that those regulations were supposed to regulate. And it brought me to a place after doing that work for about 10 years to really begin to question this Western or European system of law that we have in the United States. And our system is Western because of the influence of Europeans and as a colony of Britain, and basically writing a constitution that was based on European law. But we have a Western system of law in the United States. And that Western system of law, that European system of law, basically sees nature as dead. That nature and ecosystems are not living. They're dead things. They're inanimate. They're not animated or living things. They're dead. So forests are meant to be cut. Streams are, waterways are meant for drinking water. It's all homocentric, and it comes at it from a perspective that nature is not a living thing. Now, contrast that with indigenous communities, indigenous peoples, who treat nature and ecosystems in a different value system. So the Ponca Nation in Oklahoma talk about speaking for those without voices. The White Earth Chippewa in Minnesota, they talk about the flying people, the swimming people, and the singing people. The Yurok Nation in California, they talk about the Klamath River being a relative, a living being. And we just need to contrast that with the European system of law, which is sometimes summarized by Sir Francis Bacon, an English philosopher who knew we'd be talking about Sir Francis Bacon at Bioneers. But Sir Francis Bacon, whose most famous quote was that the job of Western civilization was to torture nature on a rack to extract her secrets. So I think all we have to do is compare kind of the singing people, the swimming people, that concept of a living being and a relative with this concept of torturing nature on a rack to extract her secrets. So sometimes when we go out and give talks, people say, well, so what? We have to use the tools that we have. We have to use the tools that we've been given. That means trying to make this existing environmental regulatory system work, which is about permit appeals and state agencies and corporations writing these regulations. What else is there? And we didn't think there was anything else out there either until we started working with communities, like a small community in northeastern Pennsylvania called Tamaqua Borough, which was faced with a project to bring dredge waste in from the Delaware River and dump it into old mine pits in the borough of Tamaqua. Small community, about 7,000 people. But that was the plan, was to bring this dredge in. The problem was the dredge had PCBs in it, polychlorinated biphenyls, very toxic stuff. Community didn't want it, just like hundreds of communities across the United States who are fighting these individual projects on a daily basis. Didn't want the project and wanted to put a ban in place. And so I worked with them to draft a local law that had them banning the dredge waste coming into those mine pits. But as the conversation continued with folks in Tamaqua, the conversation really turned to, well, this might be a way to protect humans, using the rights of people to try to stop this project from happening. But what about the ecosystems and the waterways in the borough that are affected by this project as well, like the Wabash and the Panther Creeks and the Little Schuylkill River, which feeds drinking water into Philadelphia? And we kind of got involved in a conversation with them that built on some work done back in the 70s by an environmental law professor named Christopher Stone. He wrote a law review article called "Should Trees Have Standing?" Made it into a U.S. Supreme Court opinion that dealt with plans by the Walt Disney Company to put in a ski resort in California, and resulted in this famous dissenting opinion by Justice William M. Douglas about nature having the ability to go into court directly to enforce laws and enforce rights. And that concept kind of just percolated for a while, 30 years or so, before we started working with Tamaqua Borough. And in Tamaqua Borough, we talk with them about protecting the waterways in a new way, basically recognizing this new system of environmental law that was rights-based. And so we drafted with them a local law that recognized the right of these waterways within Tamaqua Borough to exist, flourish, and naturally evolve. So kind of constitutional rights type protections for waterways within Tamaqua, and added two other elements. So there was the recognition of rights for waterways, but there was also a recognition of who could sue on behalf of those waterways, that any resident with the community could step into the shoes of the waterway to actually have the waterway be a plaintiff in court. Another thing that kind of bends our brains a little bit, because we're used to saying people as plaintiffs or corporations as plaintiffs, but we're not used to saying waterways or ecosystems or nature as a plaintiff. And that's what this law envisioned, was that not only these waterways having rights, but that residents could sue to enforce those rights in court in the name of the waterway as the real party in interest or as the plaintiff in those suits. And then providing for a remedy that whoever violated those rights would have to put the waterways back to their pre-damaged state, the state they were in prior to the violation occurring. So I think, to everybody's surprise, perhaps, Tamaqua Borough became the first place in the world to adopt a rights of nature law, essentially recognizing that these waterways have rights, legally enforceable rights within the borough of Tamaqua. The concept then traveled. Mari is going to be talking with us about Ecuador and what happened in Ecuador with the new constitution. But in the US, the development continued through places like the city of Pittsburgh in 2010, which banned fracking, hydrofracking for natural gas within the city of Pittsburgh. And then I worked with them to draft an ordinance that would recognize the rights of the three rivers within the city of Pittsburgh, the Ohio, the Allegheny, and the Menikanaehkem. And the city of Pittsburgh then unanimously adopted that ordinance as part of their code of ordinances in Pittsburgh back in 2010. And since then, about 36 communities across the United States in 10 different states have passed these rights of nature laws, sometimes connected to bans on certain activities, mining, extraction, fracking, those types of things. Others passing pure rights of nature laws, which recognize that ecosystems have certain legally enforceable rights within those communities. And then the laws have traveled through national courts, which Mari is going to talk to us about as well, through tribal nations, which Guy is going to talk about. And then the most recent iteration, the biggest event happening in the rights of nature field, at least in the United States, happened in Florida this past election day. When, for folks that aren't familiar with what's happening in Florida, they're going through a water crisis right now. Red tide, algae blooms, dead sea life being taken off the beaches by backhoes and bulldozers. Biscayne Bay on the southeastern side of Florida dropped to 0 dissolved oxygen levels a couple months ago. You don't have to be a scientist to understand that 0 is not a good number, that without oxygen in the water column, there's no life, and there was a huge fish kill in Biscayne Bay. And so folks in Florida came together, specifically in Orange County, about 1.4 million people, 30th largest county in the United States, 5th largest in Florida, to come together to say we need a change in the way that we do environmental protection here. And we think that this rights of nature stuff probably is the mechanism to get us to that heightened protection. And so worked in Orange County to create an ordinance, charter amendment that would actually amend their constitution within the county. So some Florida counties have local constitutions called home rule charters. They sought to actually amend that home rule charter of the county, which is the highest law of the county, with this law that would protect the Wekiva, Econlockhatchee rivers and other waterways within Orange County, and specifically to create a right to exist, flow, be free from pollution, and maintain a healthy ecosystem for those waterways. And then for people within Orange County to be able to step into the shoes of those waterways to enforce those rights. And on election day, this past election day in November, it received 89% of the vote as a charter amendment, and now is the binding law within Orange County that these waterways have certain rights. And in addition, there's a provision for human rights, a right to clean water, which also ran parallel with these rights of nature, rights of waterways within Orange County. So we think that was a big deal. It's the biggest municipality in the United States to have passed a rights of nature law at this point. So biggest municipality, 1.4 million people. And I'll just close here before handing it off to the other panelists to talk about how this concept, this rights of nature, which once was treated as a fringe kind of edge concept. When I was talking about some of this stuff 15 years ago, we had people walking out of the room because they thought it was just crazy or insane. That it's moved more to the mainstream over the past 10 years, which is Tulane Law School, Vermont Law School, Levin Law School in Gainesville, Florida, have held conferences on rights of nature. The Democratic Party of Florida has placed a rights of nature provision into their state party planks, so into the state party platform, recognizing support and supporting rights of nature laws as they move across Florida. A lot of folks don't know, I didn't know this until it was raised a couple years ago, but the Democratic National Party in 2016, and this is the Democratic National Party, the DNC, the folks who put the platform together, actually included a rights of nature plank in the 2016 National Party platform dealing with support for rights of nature, passage of rights of nature laws by indigenous communities in the United States. So that was a pretty big deal as well. Major newspapers have now endorsed it. League of Women Voters, at least for the Orange County Initiative, endorsed that as well. And so rapidly moving towards what I believe is the next emerging frontier of environmental law in the United States. I have very little doubt that this is the paradigm that's going to supplant eventually environmental law as we know it in this regulatory permitting scheme and state agency stuff, whereby we try to protect the environment through those structures. And the final word I'll say before passing it back is that a lot of people think, well, it's enough to say nature has rights. I've been at conferences where people say, well, of course nature has rights, and we're just going to treat nature as having rights. Well, that's great, but nature has no rights unless we actually physically recognize those rights within law. And that law can be an ordinance, it can be a charter amendment, it can be a citizens initiative, it can be a bunch of different things. But you have to codify it into law. Otherwise, it has no meaning in terms of enforcement. To try to stop projects that are damaging or violating these rights of ecosystems within these specific communities. It's about lawmaking to us. It's not just about the cultural belief, which is important to animate the lawmaking, but it's about the lawmaking itself and recognizing rights in law. Basically about kind of hijacking the Western system of law with an indigenous value system, which is backed with these rights of nature to make them legally enforceable. So I'll leave it at that and look forward to answering questions when we get to that stage of the panel.
Thank you, Thomas. We are next going to hear from Anaquet Guy Reiter. He's a traditional Menominee who resides on the Menominee Reservation. He's the executive director of a Menominee Indian community organization called Menikanaehkem. He's also a community organizer, an activist, an author, an amateur archaeologist, and a lecturer. And he's also a member of the Menominee Constitutional Task Force. He's organized many, many events that have uplifted the human condition and demonstrated how enriching the Menominee culture is. He's lectured at universities on the connection between Menominee Indians have to the Menominee River. He's also written articles for Environmental Health News and others. And when he isn't working, you'll find him enjoying time with his wife and his children. He's an advocate, as we have learned, for Indigenous peoples everywhere and for Mother Earth everywhere. And this includes our good fortune of having worked with Guy on a rights of nature resolution for the Menominee River earlier this year. So please join me in welcoming Guy Reiter.
Thank you, Mari. Thank you, Thomas, for that talk. Yeah, I wanted to talk a little bit about who I am and where I come from. But first, I would love to be able to introduce myself in our original sacred language, which is not a foreign language. It is from this land. It's one of the original languages spoken here. I'm just going to introduce myself in that language. Poso, Anaquet Menikanaehkem, Wapasha Nitotam, Kashikna Nitski Wakin, Waiwana Nitskes Mauni Nitanawe Makanakeos, Aitua, Waiwanan. So, like I said, my name is Guy Reiter. My real name is Anaquet, and I am the executive director a nonprofit here on a Menominee Indian reservation by the name of Menikanaehkem, and that name roughly breaks down to like a really healthy village builder, I guess is the way you would understand that. And it's interesting is because our original village from the Menominee Nation here, our original village, one of our original villages, was located on the Menominee River. The Menominee River is the natural border between Upper Michigan and Wisconsin. The Menominee Nation is one of the longest living inhabitants of this area. We've been here a lot longer than others. Our creation story, our oral history states that we originate from the mouth of the Menominee River. That's where we come from. But our village that was located there was called Menikanaehkem. So that name that we carry, Menikanaehkem, is a kind of a throwback to that original name. So for us here, we have been forced to defend that river from a project by the name of the Back 40 project, which is a sulfide mine, a gold and zinc mine. The mine is potentially going to be located on the Michigan side of the river, but the Menominee River, but it's just a bit short of 150 feet short of the Menominee River, which flows into Lake Michigan. So we've done lots of things to try to raise awareness and do many things to let people understand how devastating this project is and could be. The thing that we wanted to also to people to realize is that, we wanted to stand up and speak for all life that it resides around that river and in that river. That river, that Menominee River, goes back very, very far into our origins as a nation, and it's the center of our universe, and we're forcibly removed from it in the 1800s, and we settled on our current reservation here in 1856, which is about 60 miles away from the mouth of the Menominee River. So we're not too far away, but we are still within our ancestral homeland. But it seems that in some ways that we've kind of grown a little bit detached from that river. And it wasn't until, we had to really push back on this project that we really, really started to ignite that fire again and that connection with that water and with that river. So one of the things that we have done is what Mari said a little bit before, is we did draft a resolution that was actually just passed earlier this year, January of 2020. We passed a resolution, the tribe did, the Menominee tribe, recognizing the rights of nature and recognizing our connection to it. And I think that part is a big part of that resolution, is letting people understand that, it's yes, we don't necessarily live along that river now, but we were forcibly removed from that river, but we lived along that river for thousands and thousands of years, and that connection, and there is no treaty or there is no law that's ever going to break that connection. That river, was given to us by the Creator, and is in our protection. So we try to speak up for it and do as much as we can when the time presents itself. And there's a lot of ceremonies, a lot of things we do along that river. There are definitely a lot of ancestral burial mounds and archaeology sites that are located. So we do what we can. The resolution was really just a start of it. We wanted to also focus a little bit in on getting a constitutional amendment for our own tribe here. The interesting thing about the Menominee Nation tribe is that we are the only tribe in Wisconsin that is not a public law 280, which just basically means that the state of Wisconsin has no jurisdiction over us. So we have our own judicial system, and we have our own constitution and our own police force. So there's some avenues that we can explore that at this point is a little different for other tribes. So that's something that we've focused on, and you know, I've been doing this work for a while, doing a lot of environmental work, definitely trying to speak up and do what I can for people to recognize how beautiful our water is and how important our environment is and our Mother Earth, and that we can't take her for granted. Sometimes I think we all get caught in this hustle and bustle of life, and we forget what's really important at times. And you know, we just take it for granted that when we turn that faucet, that you know, water is going to come out of there, and clean water, and that when we go outside or you know, breathe that beautiful air, that it's going to be healthy and clean, and we don't have to worry about it. But you know, those things are definitely things that we should recognize every day, to try to just slow down and realize that those things, a lot of people have fought for those things, and people are living and dying to have clean water and clean air right now. And you know, it's a part of who we are. So I wanted to just to say about that much. I mean, I could go on and on about our tribe and the things that we're doing, but one of the most important things that I really wanted to say and let people understand, whoever's viewing this at this point, is to today, at least start today, when you take a drink of water, to really slow down and appreciate that water. Take the time to acknowledge it and thank it for the journey that it took in its life to get to your cup. And sometimes, you know, when you're feeling overwhelmed and things are moving quite fast, that you know, you remember to put yourself in creation, to put your feet on our earth and really feel her, and always be reminded that she is always there holding us up, and she's always been holding us up, and we shouldn't take her for granted. You know, even in those cities, you know, you see those cracks in the sidewalk, and those cracks are designed so our beautiful mother can breathe, and also, you know, always reaching out for us, and she is our greatest teacher. So I would ask that much. Definitely, you know, appreciate the opportunity to be on this panel and share a little bit in who we are, who I am, and some of the work that we're doing, and definitely, you know, we're just getting started in some areas, and we must definitely always think of those 7 generations, those ones that are still coming here, that haven't arrived here yet, and you know, they deserve the right also to live life to its fullest and experience this earth, and we should think of them ones too. So I want to say about that much, and I want to pass this back to my good friend, my colleague, Mari, and I appreciate your time and your ears. Thank you. Bye bye.
Guy, thank you very much. I happen to, well, I really appreciate the work that you've done, and I printed out the resolution that the Menominee tribe passed back in January of 2020, and I just wanted, if I could, Guy, just say a word about it, just read from it briefly, because I think it's really catches both what you described in terms of the law, meaning recognizing rights of the river itself, but the reason to do so. I won't read the whole thing, but just to say that there's a very, I think that the tribe did a really made a very important statement with this resolution, and talking not only about the need to recognize the rights of nature, but why to do that, and speaking to the relationship of the tribe with the river. And just to reiterate what Guy said in his presentation, just reading from the resolution, it says, the tribe understands and recognizes that water is essential to life, and that the Menominee River is, in fact, the very origin of life for the Menominee people. And it goes on to say that the tribe recognizes that environmental laws which regulate the use and exploitation of nature are incapable of protecting the Menominee River and Mother Earth. and that in order to protect the Menominee River, their place of origin, it must secure the highest protections for the river through the recognition of the river's own inherent and legal rights. So incredibly powerful words, and paints a very clear picture of the need and the threat that the water faces and the river faces, and to the relationship of the tribe with the river, their place of origin. So I wanted to share that, and the work that Guy is doing is really very, very important. So again, my name is Margil with the Center for Democratic and Environmental Rights. My role today is to talk a little bit about what has happened in terms of the development of the rights of nature in law and policy in places like Ecuador and other countries. So Ecuador is the first country in the world to enshrine the rights of nature within a national constitutional framework. Chapter 7 of Ecuador's constitution recognizes that nature, or Pachamama, possesses certain legal rights, including the right to exist and the right to be restored, the right to evolve. That occurred in 2008, and Thomas and I worked with the Constituent Assembly there to figure out what is this rights of nature? How do we put it into a constitution, which had never been done before? Ecuador is the first country to do this, and in that it's really a remarkable thing to do. It's very difficult to be the first to do this, to really mark a very fundamental shift in the relationship of humankind toward the natural world. And in fact, the Constitutional Court in Ecuador, which has started to hear rights of nature cases, they talk about the constitutional rights of nature as, indeed, and I'll quote from the court, that this creates a, quote, new form of relationship between human beings and nature, meaning that we're talking about changing fundamentally how we actually govern ourselves. Human beings govern themselves toward the natural world. What we have done up until this time has been treating nature as without rights, as an object, and environmental laws, conventional environmental laws that we all might be familiar with, regulate how we use nature, how much water we use, how much we can pollute the air, the water, the soils, how many fish we can take out of the ocean. All of these things are about how do we use the natural world, and environmental laws legalize that use. Thomas talked about, all of the criteria, all of the things that we are seeing that mark just how much destruction we have impacted upon the natural world, and the need for a fundamental shift in how we treat nature, which means not only doing voluntary things that limit our own impact on nature, but actually driving that into even the most highest forms of law, such as a constitution in Ecuador. So since Ecuador established the rights of nature, enshrined it within their constitution in 2008, we now have Bolivia has a national rights of Mother Earth law. Uganda has incorporated the rights of nature into their National Environmental Policy Act. You have courts from the highest courts on down in Colombia recognizing rights of the Atrato River, of the Amazon region, of paramos and other ecosystems. In India, you have state courts which have recognized rights of the Ganges River, Mother Ganga, the Yamuna River, and other rivers and ecosystems within that state. In Bangladesh, just earlier this year, you have the highest court there affirming that all rivers within the country of Bangladesh possess legal rights. And across the United States, of course, we have rights of nature laws in place at the municipal level. In Brazil, local communities have now adopted rights of nature laws. So we're seeing this real expansion of this new legal framework. And from our perspective, we work with partners in different countries that even though we're cutting across different cultures, different legal systems, different languages, different perspectives on human relationship with nature, that we're seeing this sort of common cause, a consensus growing, if you will, that something really fundamental needs to change because of climate change, because of accelerated species extinction, because of the impacts on ecosystems, because we see coral reefs dying and bleaching, because we see species disappearing, that something really different needs to occur. And that means not only changing how we govern, but change how nature itself is treated under the law. And this expansion of lawmaking at constitutional level and state and local levels is going beyond the places that have already put this into law. We're now seeing in Philippines, in 2019, we worked on national legislation, which has now been introduced into both houses of the Filipino Congress to establish a national rights of nature law within Philippines. In Sweden, we worked with a member of parliament there to introduce a constitutional amendment to amend the Swedish constitution by enshrining the rights of nature. In other places, like in Australia in 2019, we worked on state level legislation with Member of Parliament from Western Australia, Diane Evers, who introduced the first rights of nature legislation introduced anywhere within Australia. And we've worked with our partner organization, Australia Earth Laws Alliance, to develop a model rights of the Great Barrier Reef law for local, state, and national adoption. In places like Nepal, where we've been working on establishing rights of the Himalaya. And in other places, we're seeing these different rights of nature efforts moving forward as more and more people are saying, essentially enough is enough. We can't pretend that we'll be able to protect nature under conventional, traditional environmental laws, which regulate how we use nature, how we exploit or destroy nature. This is really a transformational moment. I think that we're because what we're seeing, everyday headlines about environmental harm, we're at this place that we're seeing, I think, this cultural shift, which is essential to the legal shift that's necessary, and those two things moving each other along. And one of the key developments, I think, that we've seen within the rights of nature movement is not only just lawmaking to recognize rights of nature on the whole, we're also seeing, as Guy described with his work with the Menominee tribe, is recognizing rights of particular ecosystems, such as a river. Also, the White Earth Nation, we worked with to recognize rights of a plant species, Monoman, wild rice, the first law to recognize the rights of a particular species. So there's different ways that people are coming at the rights of nature work, nature on the whole, particular ecosystem or species, local level, state level, national level. And as this work is developing further, now that we've had laws in place for the last, 10, almost 15 years now, in places like Ecuador, which has had it in place for over a decade in the Constitution, as I mentioned, there are cases that are going forward through the courts there. We've filed amicus briefs and also working on legislative reform with the National Assembly to try to improve and enhance the enforcement, implementation, and defense of the rights of nature there. In places like Blue Hills in Australia, our associate, Michelle Maloney, who works with us here at the Center for Democratic and Environmental Rights, is working with the Blue Hills Council in Australia, the first local municipality to pass a policy to say, we want to figure out how do we move our own operations into a rights of nature focus so that our activities are not impacting what the rights that nature needs and nature wants to be fully protected. In places like Ecuador, again, we're moving into that implementation and enforcement phase because the law's been in place there in the Constitution for over a decade. And I think it's really quite interesting as we see the courts sort of wrestle with this new area of law, this expansion of the body of rights to now include nature or Pachamama in Ecuador. And the courts have first had to, number one, affirm indeed that nature possesses constitutional legal rights. Number two, that those rights are enforceable and can be defended. Number three, and this is important, particularly in Ecuador, where there's been a sort of tension about how do we implement this in the best way, in a proactive way. The Constitutional Court has said this, that it's a fundamental duty of the state, that is the national government, to, quote, respect and enforce the rights guaranteed and established within the Constitution, so that the state, the government, has an affirmative obligation, a duty to implement and guarantee that the rights of nature are being met, being upheld, that their activities are consistent with those rights. And the court has gone beyond that. There's a case you may have heard of called Los Cedros, which is before the Constitutional Court right now, regarding mining in a protected forest within Ecuador. We filed an amicus brief on that. And if you're interested, you can find that on our website, both in English as well as in the original Spanish. And one of the arguments that we make, that is just reiterating what the Constitutional Court has said, is that by establishing the rights of nature within the national constitution, the highest form of law that they have within that country, that's placing a higher standard for environmental protection for nature beyond what conventional environmental laws had previously established, that it's actually putting in place a higher standard. And that means, for instance, that we're finding that just because like the government might issue a permit to a corporation to conduct a certain activity, if that activity is causing harm, it could be that they're not meeting the constitutional standard. And that's one of the things that's before the court right now. And so we'll be able to keep folks up to date on what that looks like as we continue to move those amicus briefs and follow the court process over this next number of months. And then I also want to mention that the National Assembly, the legislature within Ecuador, is also undergoing a legislative reform process, and that they're reviewing all of their major environmental laws related to the Galapagos, related to just national environmental decision-making and permitting and so forth, just occurring over the past year. We've engaged with the National Assembly on this and their Biodiversity Commission to talk about how do we begin to better improve our environmental governing decisions. The permits that we issue to a mining corporation, for example, or another kind of industry, farming, other things. How do we actually begin to make decisions that put criteria related to the rights of nature first and foremost, so that we're not making environmental decisions as a government that would violate or infringe upon the constitutional rights of nature? It's a real shift in terms of how governments have operated in the past, which was that laws legalized things, like mining, fracking, offshore oil drilling, other kinds of activities, now beginning to make that shift to say that if we can't have environmental laws that are going to violate the rights of nature, and how do we make the shifts within those laws to ensure that they actually become consistent with these constitutionally enshrined rights? So we're seeing a lot of development there. And it's a really important process that I think is occurring in Ecuador as well as in other places. And I think there are just some common elements that I wanted to leave us with when we think about the rights of nature in law, which is that people are coming at this from different places. Some from a very practical place, that they have, they're feeling a threat coming into their community or their state. Could be fracking or another activity, and they look at existing environmental laws and finding that they're not enough to protect the place where they live. So they're coming at it from a very practical standpoint, that current environmental law is not allowing me to protect not only myself, but nature from whatever the harm is. So there's practical reasons, there's spiritual reasons, and we've seen faith communities begin to move more into talking about and endorsing the rights of nature, such as with the Philippines legislation that's now been introduced into the Congress there. You see the Catholic bishops within Philippines endorsing that measure. You've had the Pope talk about that there is a right of the environment, that the right of the environment does exist. So you see faith communities moving into this sphere, which I think is really important in helping to shape how we think, culture, and so on. So we're having this cultural shift occurring. We're seeing more discussion in academia and other kinds of fora. But then there's also just the legal piece and the key kind of elements that we're seeing, and that when we work with different places, different communities to develop rights of nature laws and legislation and policy, core elements of these are, number one, recognizing that nature is itself a living legal entity, that nature possesses certain rights. Those rights can include the right to exist, the right to thrive, the right to regenerate, the right to evolve, the right to be restored, in places like Orange County, Florida, which Thomas mentioned, like a right to clean water, a right to have water not to be polluted. So different core rights are being recognized for nature to ensure that nature has the protections that it needs to be healthy, robust, living ecosystems and species. And then a third piece to this is that not only is government empowered to enforce and defend the rights of nature, but that people are as well. So people who live in a place like in Orange County or in Ecuador or in other places, that they are in fact empowered to enforce and defend nature's rights on behalf of and in the name of nature, which expands really how conventional environmental laws traditionally work, that we ourselves have to have experienced some sort of harm as a result of harm to nature before we're able to go into court to try to protect nature. Within rights of nature laws, recognizing how difficult it is for people to, sort of stand in the shoes of nature to protect nature within courts, rights of nature laws generally include provisions which empower people to automatically be able to speak on and represent nature's rights. Really critical piece to empower people and communities, NGOs to be able to do this. So we see it as a very fundamental shift. We see it as very much a growing movement within tribal nations, within the United States, as well as around the world. And I'll stop there. We have a number of questions, so I want to open it up now for folks who are watching to type in questions, and we're going to start to go through those, and I will facilitate those and ask them of our different panelists. So thank you, everybody, and let's move to some Q&A. The first questions that we have, and Thomas, I'm going to pose this to you. Several different people have asked a question about preemption. That is that we're seeing state and federal preemption being used to prevent people from protecting the environment. And we've seen this not only, and this is just from the questions, just so folks have an understanding, laws to preempt rights of nature, laws, rights to preempt plastic bag bans, rights to preempt states or localities from labeling food products as having GMOs or not. So Thomas, I'm going to ask you to respond to this, and Guy as well, if you'd like. Can you tell us a bit about what preemption has looked like with rights of nature and what we can do to overcome that challenge?
Yeah, so it's a great question, and it's part of the reason why democratic is in the name of our organization as well as environmental, because the two really go hand in hand. And the place where we've seen that happen to the greatest extent have been Ohio and Florida. In Ohio, folks in Toledo passed the Lake Erie Bill of Rights. People may have heard about that, recognizing Lake Erie as having certain rights. First thing that happened was a lawsuit was brought, and that lawsuit eventually overturned that law, the Lake Erie Bill of Rights. But in addition to that, the Ohio legislature stepped in and adopted a law as part of the budget bill for the legislature to preempt the passage of any more rights of nature laws by municipalities across the state of Ohio. So for folks that aren't familiar with the legal term preemption, basically means that the state legislature has stepped in to constrain or restrict the ability of municipal governments, so cities, towns, villages, counties, to adopt certain kinds of laws. And under the US system of law, this Western system of law that we have, it's very hierarchical, which means that state governments have an almost unquestioned right to constrain the lawmaking authority of those municipalities within their state. So we've seen it in Ohio, we've seen it in Florida, where as the Orange County initiative was on the ballot, Governor DeSantis stepped in and signed a bill passed by the legislature, which preempted all municipalities within the state of Florida from passing rights of nature laws. And a lot of times people just say, well, that's it. It's game over. We're done. We can't do anything here because the states have stepped in to do this. Well, no. What the states are doing in essence is by restricting and constraining what kinds of laws substantively can be passed by those municipalities are actually violating the right of people within those communities to decide what their community is going to look like over the next 20, 30, or 40 years. Something we refer to as the right of local community self-government. And so when we're in courts, when we're arguing in lectures and speeches and court of public opinion, we talk about the need for a recognition of the right of local community self-government as a constitutional right to restrain what state legislatures are currently doing, which is to say that in shorthand, state legislatures act unconstitutionally when they override the right of people in those municipalities to adopt rights-based laws, which recognize new rights, not only for the people there, but also for nature. So rights of nature within the communities. That reached ahead, kind of that argument, when folks in Florida brought a lawsuit against the state saying, you can't preempt us when we're attempting to pass these kinds of laws because you're violating our constitutional right to democracy, to local self-governance. And that lawsuit was brought, had its intended effect, which was to stop anyone from using the preemption law that passed in Florida to try to strip the Orange County initiative off the ballot. But I think what you're going to see is more and more of those kinds of direct, open challenges to preemption as a doctrine. So the ability or legal authority of the state to override at will these municipalities that are passing these kinds of laws. And the reason why the democratic end of things goes hand in hand with the environmental rights and rights of nature is because without expanding the portal of what cities, towns, villages, and counties can adopt, you can't get these things through in an enforceable way. So it's not just rights of nature we're talking about democratic rights of communities to adopt rights of nature laws. And that's how the two kind of go side by side. We did a law review article a couple of years ago on this right of local community self-government. Just add a final thought, which is, people find it kind of foreign to say those words, but in the United States, at least up until the late 1800s, we had a constitutional right of local community self-government in at least 20 states. So state Supreme Courts upholding a right of local community self-government that was immune from state preemption. So I think in line with this push towards structural change that we need in our system, not just passing rights of nature laws, but making sure that state governments can't override that lawmaking at the municipal level. And I think what's happening in Florida and other places is people are also looking at now changing state constitutions to textually, outside the courts, but textually limit what state legislatures can do in terms of those preemption powers.
Thomas, thank you. Guy, I didn't know if you wanted to add anything to that. Okay, so the next question, Guy, is for you, and I suppose it might be related, which is a question regarding how tribal law, tribal governance relates to, maybe in conflict with, parallel, harmony with state and federal law. Can you describe a little bit of that relationship there?
Yeah, I mean, I'm not a lawyer, and I'm not versed in tribal law per se. I've just kind of had to deal with it and many things that we've done here. So I think, a lot of times, one of the things that obviously that we have that other groups of people don't is and all of our nations in the United States have them, but here in the area that I'm the Great Lakes area here, we have treaties that we signed with the federal government, and a lot of those treaties, we have the right to hunt and fish and gather in our ancestral homelands. Now, there's the treaties are the supreme law of the land, and even though they've been violated, since the conception of them by the United States government, but we still take them very seriously, and we try to use those in a way that benefit not only us but all people. I think we want clean water and fish and clean air for everybody. It's not just us; it's for everyone. So the tribe here, in Menominee is unique in a sense, like I said before, that they have we have our own abilities to write our own laws here that govern ourselves on the reservation. A lot of our laws and ordinances that we pass, reflect, things here in our community that don't necessarily reflect, the broader world. It really truly is sometimes, living like in a different, country at times. The way in which we go about things and the way in which the United States and even the state of Wisconsin goes about things and local governments operate we do have a legislator, 9 legislators here on our reservation, and you know, a chairman who kind of is like the president, I guess, in a sense. So sometimes it's very tricky about jurisdiction too, and there's a lot of layers to it, and I don't think that there's probably anybody that really truly understands everything from A to Z when it comes to, you know, federal law and tribal law and county law and state law. But we try to figure out how we can you know, best reflect our own culture and ideas, and things are definitely, our laws and ordinances are definitely reflect who we are, but there are things that we do that does reflect the broader world as well, in the way in which we govern and things. And I'm sure you can hear my little dogs in the back, so I apologize for that. They get very animated when you talk about federal law and tribal law. So.
Guy, thank you for that. Thomas, this is going to be a question for you related to corporate rights. So there have been some questions regarding that corporations have certain legal rights. And is it the same idea when we talk about recognizing that nature has rights?
Yeah, I think the question is aimed at kind of messaging and how to talk with people about stuff. I think in Florida, it became an increasing kind of meme about when folks said, well, rights of nature, that's crazy. Well, people then said, well, corporations have rights, so why should nature have rights? And I think that's a good way to try to reach people. We just have to be careful not to legitimize corporate rights, because for folks that are in the know, corporations have the same constitutional rights as persons in the United States as a product of the courts, especially the U.S. Supreme Court in the 1800s, basically conferring certain Bill of Rights protections on corporations. So we just have to be careful sometimes not to legitimize corporate rights while we're trying to give birth to the rights of nature. But this whole, you know, corporate rights, corporate constitutional rights, just like preemption is a legal doctrine in which states can legally squash communities who are running outside the box or coloring outside the box, that in many ways corporate constitutional rights is another doctrine that kind of catches us in a box of organizing to say you can do everything you want at the community level except anything the state has told you not to do, and anything except that corporations have rights that you can't violate. So your activism is kind of defined by those doctrines. And the corporate constitutional rights doctrine is very powerful because you can't pass anything that takes a corporation's property, for example, without paying them for it, as a virtue of corporate Fifth Amendment rights under the US Constitution. So we're all kind of operating in this box of, we call it a box of allowable activism. You know, we're allowed to do certain things, but we're not allowed to violate these walls of the box. And one is, of course, preemption, the other corporate constitutional rights, and this whole concept that municipalities are subordinate to the federal level of government. What's interesting about tribes, you know, playing off what Guy just said, which was that tribes kind of sit in a higher place than municipalities under the law. And I think there's a lot more room to roam for flexibility with tribal lawmaking, and especially enforcement in tribal courts, than trying to get Western courts, you know, federal courts or state courts to try to get them judges to agree with enforcement of rights of nature law. So I think the tribal areas is a great area for more flexibility than the municipalities have under this, Western system, federal, state, local that we have.
Thank you, Thomas. I want to direct the next question, Guy, to you. There was a question about an effort to return lands to tribes, and how, do you see that as a beneficial piece or related in a positive way to the growing rights of nature movement within tribal nations?
Yeah, I know, that we have some sister organizations that we work with in South Dakota that, the Black Hills still belong to the Sioux peoples, and I think that maybe I'm a little biased, but I feel that if those lands were rightfully back into the I don't want to say ownership, but into the caretaking of the original peoples, I believe that they, would know best how to manage and how to flourish, have that environment flourish. Our relationships with our lands, go back many, many years, and if we didn't know what we were doing, we wouldn't be here, and we wouldn't have had what we have now, if we were just not equipped with understanding our environment. I think one thing that is absolutely true about our ancestors, or my ancestors, is that they were masters of their environment, and knew when and where to do things to benefit all things, not just themselves, but all things. And what comes to mind is the forest management. Like when you see in California, our people had burned those plants and those prairies prior to any kind of forest fires. So they knew how to manage, and they knew when and where to do those things. And we do that here at home. We've been doing that as long as as the history shows. So I think that it wouldn't. They go hand in hand. I think the rights of nature and getting land back are definitely connected, and I definitely believe that it would be a much easier process if what Mr. Linzey had said earlier, if we could go through tribal courts and not in the Western courts, to be able to establish some of these things. So I definitely agree.
Thank you. Thomas, I wanted to ask the next question. We've had several questions related to trainings, curriculum, and you've done a lot of trainings around this over the past, especially during the pandemic. I wondered if you could talk a little bit about what that looks like, what we might be able to offer people who are interested in learning more, or potentially bringing this into their own community or country.
Yeah, so COVID has really transformed how we do a lot of this work. Used to be getting on planes. We were talking to a guy the other day about how different it is, personal relationships and having somebody in person and doing these trainings. But we've basically transferred all of the work that we were doing for those in-person trainings to virtual trainings. And so now we run the gamut of basically asking ourselves, what do groups need to move through to an endpoint where they're adopting rights of nature laws in a community, in a town, in a city, in a county, and then actually enforcing those laws. So we have the basic, what are rights of nature kind of thing, an hour that we offer for free to communities who just want to know what it is. I mean, just what is it, and a chance to ask some questions. And then if the group decides to move further in, we have more advanced trainings also that we do at no charge. But the next stage is really a multi-hour, what would a law look like in that particular community? How do we help them draft that law? And then the third workshop is really a really advanced one, a lengthier, day-long kind of workshop, which takes you through, what problems are they going to be talking about this stuff? How do we message what we're talking about, rights of nature? What reading materials can we go through and talk about? What's this legal theory about the right of local community and self-government? So basically, our organization is kind of focused on how do we give support for each stage as a community moves through that process towards drafting and adopting a rights of nature law, and then hopefully enforcing it. And there are also other groups that we've started to work with that are focused on state constitutional changes. And so that's a whole different kind of training that goes into that. And then, of course, we have the international communities that we work with. Those also require certain online training. So basically, wherever you are in the process, if you're serious about moving forward to put a group of people together to see what kind of lawmaking is available in your community, because it's very complicated in terms of state by state. What folks have in Arkansas is much different than what folks have in Colorado to use. In some places like Virginia, you're basically reliant on your state elected officials to pass a rights of nature law. And that's few and far between for elected officials to pick this up and run with it. Most of these laws are passed via ballot initiatives, where in your state, the state constitution or state law gives you the power to actually collect petition signatures, submit them, qualify something for the ballot, and then vote on it on election day. And so a bunch of different ways to get through that, through those bushes. But we're kind of trying to be the guide sometimes to help you through thinking about what you need, whether this is actually something you want to do, and how do you get to that end stage of passing something and enforcing something.
Thank you. And so I don't want to leave people feeling that this panel that, we disappear once we all hit leave session. So I wanted to do a couple things because we have a few minutes left and we have a lot of questions, but this has come up, Guy, with respect to your work that you're doing, the resolution that was passed in January. People are interested to know, how they can learn more or how they can connect with you. We did post into the chat the website, Menikanaehrebuilders.org, but I wanted Guy to provide you an opportunity here to tell us if there's other ways that people can connect with the work that you're doing, because we've had a lot of questions of people asking this in a different ways.
Yeah, we have all the social handles. Our Facebook page is Menominee Rebuilders on our Facebook page. I know there is a Menominee Rebuilders Twitter, although I'm not very Twittery, if that's the word. There's a lot of social media. You can find us all over. If you just Google my name, Guy Reiter, you'll come up with lots of things too. They're readily accessible.
Great, thank you. And also I wanted to say the same for the Center for Democratic and Environmental Rights. Thomas mentioned the different trainings that we offer. We have a page on our website about these different kinds of trainings, what they involve, how to get in touch with us if you're interested in finding out more or scheduling something. Our website is centerforenvironmentalrights.org. There was also some questions about different laws that have been passed with the rights of nature and how to find those. We now have a law library on our website that you can also find there. So I encourage everybody to get in touch. We also have all the social media. We're at Rights of Nature, and Facebook, we're Center for Environmental Rights. And again, we see this, one of the things that we love about Bioneers is that we have, every time we've participated in a panel or a keynote or other kind of session, those, lots of relationships build from that, a lot of partnerships build from that. And so we see this, our time here today with everyone too, as a starting point. And we deeply encourage you to contact any of us about taking next steps forward. We do have time for one or two. We have about 5 minutes left, so I want to make sure that we can get in as many questions as we can. There's been lots. And so one of the questions that we have is related to, and I'm going to take this one for myself. Somebody was asking a question about when we're thinking about off Earth, meaning when we're thinking about the atmosphere or even beyond. Some folks might know, there's lots of governments and industry looking at the moon, for instance, as a potential place to do extractive activities. And so a couple of things related to sort of off Earth. Number one, we have worked with folks on protecting atmospheric system, the right of the atmosphere to be healthy, to be unpolluted by humankind. And then off Earth, and by that I mean more focused on the moon, is we've been working with folks over the last number of months on developing a draft of a declaration on rights of the moon, including ideas such as the right of the moon to be free from damaging extractive activity. And so that will be coming soon, and I'm working on that with some partner groups and including our associate here at the center, Michelle Maloney, who's based in Brisbane, Australia, focusing on recognizing that human activity on Earth has been quite destructive. And how do we prevent that from occurring off Earth? And some might say, well, that's, we have enough problems here on this planet. But the reality is that there are real plans being made to begin to use the moon for extractive activities, to fuel industry, as well as a stepping off point potentially for travel to Mars and other planets. And so there's a real potential for damage there. And so there's discussion that is occurring about how do we move beyond just our home planet here and making sure that we don't off-Earth our human destruction. So that's one thing that there was a question related to that. So I wanted to talk about it. Here's another question that I wanted to share is, Thomas, I'm going to ask this of you in terms of how could rights of nature counter the moves that are being made to allow water to be traded on Wall Street as a commodity like gold or other elements. I know that you've thought a lot about the work around investment and Wall Street, and this is, I think we only have like 3 more minutes, but I wanted to see if we could get this question in.
Yeah, it's a great question. I don't think a lot of thought has gone into that particular area, but in terms of the local self-government stuff and how it kind of buffers or goes hand in hand with the rights of nature and environmental rights, I worked on some time ago a local law that would ban investment companies within a community or a city from actually financing fossil fuel projects. So I think we need to kind of open our brains up that it's not just about rights of nature. Rights of nature are a component of moving forward with better protections, heightened protections, rights-based protections for the environment and ecosystems. But a lot of this work, again, is democratic. It's about democracy. It's about how we see ourselves and what kind of change agents we see ourselves being and what structural changes need to be made. I mean, if there's a right of climate, which essentially the White Earth Anishinaabe people in Minnesota passed with our help this rights of wild rice, which recognizes that Monoman or wild rice on the reservation has certain rights to a certain climate because the climate change is driving the rice off the reservation, the growing area of the rice off the reservation. So if there's a right of climate for the rice, what does that mean? Well, how can it be enforced against a pipeline, for example? Because a pipeline with oil flowing through it automatically is accelerating global climate change, which is violating the rights of climate and right to climate that the Monoman has on the White Earth Reservation. So how do we get creative about actually doing enforcement about these kinds of rights, not just having them sit there as a feel-good thing, but actually driving them into enforcement against these projects like water privatization, which is essentially what we're talking about with is trading, putting a value on water supplies. But that same kind of codification, whether it's the RED agreement, the carbon sink stuff and forest values of forests, how do we begin to fight that with this concept? I think the sky's the limit. It's been so hard over the past 15 years just to get these laws in place. Now I think we're moving to that next inning, which is how do we actually take these and enforce them against real stuff? Because that's the whole reason for doing it. It's not just to have that cultural awareness and position nature in a different place, but actually begin to enforce this in courts of law. So it has real impacts against these projects that are damaging not only ecosystems and municipal communities, but tribal communities and the earth. Because in the end, that's what we're talking about. We're talking about protecting the earth through a different kind of paradigm and changing the legal system to reflect that.
Yeah, thank you. So we are at the end of our time. I want to thank Bioneers for having us, inviting us to join them today. Guy Reiter, thank you very much for sharing your work with us today.
Thank you, Mari.
Thomas, thank you for sharing your work as well.
Thank you. Thanks to Guy, too.
And thanks, everybody, for joining us again. Please don't hesitate to reach out to any of us. We've shared our different social media and websites. We really look forward to hearing from you and just really appreciate everyone's time. Thank you.